Welcome. A judge has approved Jason Trawick, who is the fiancé of Britney Spears, his application to become Britney's co-conservator. Her dad right now has been the conservator of her financial affairs, and for some reason she believes that having Jason as part of that will give her more control, apparently. My guest here to talk about this is retired Superior Court Judge Santa Clara, California, and the host of the Family Law Channel here on the Legal Broadcast Network, Judge Eugene Hyman. Welcome.
Thank you so much.
So what kind of leverage does she get by having a fiancé act as a co-conservator?
This presents several issues that are a great opportunity to discuss for purposes of our listeners in terms of what conservatorships are all about. Mm-hmm. In terms of the overhanging principles, there's two kinds of conservatorships. One is sort of for the mentally ill, people mm-hmm. traditionally schizophrenics, and there's a different system in place for them because there's a possibility of hospitalization. Mm-hmm. And then the other kind of conservatorship is usually for people that are impaired, and they can be impaired different ways. They can have dementia, Alzheimer's, mm-hmm. or substance abuse, which is sort of Britney Spears' historical medical significance with respect to her issues. Both conservatorships, because of prior abuses years ago, well, probably decades ago, so court systems, what they have done is to require the legislature has enacted laws that say, hey, a conservatorship, whether it be a temporary one or a permanent one, they all expire regardless as to the type or nature in a period of a year, in which case then there has to either be an application or some other kind of method for getting them re-reviewed by a court and getting them approved. Now, when a petition for a conservatorship is filed, regardless as to the type, the following happens. Number one, probate investigators that work for the court do an initial evaluation in terms of getting records and things of that nature to see whether or not a prima facie case, which means a basic case has been made, that this person in fact needs a conservatorship. And there's two kinds of conservatorship. One's of the person and the other is of the estate. Of the person means that this person needs to have someone making medical decisions for them. Mm-hmm. And if a person needs medical decisions, then they're going to need the estate, which is their financial aspects. Okay. So it's possible that a person could be able to make their own medical decisions, but is impaired enough that they can't or shouldn't be making financial decisions, in which mm-hmm. case a person's appointed to deal with that. Usually there's one conservator, and that person is responsible for both, and that person has the responsibility for the financial. Mm-hmm. Depending upon the size of the estate, they may have to hire experts, accountants, mm-hmm. and things like that. And then you have probate examiners. They're the ones that review the accounting records and things of that nature that are filed with the court to see whether or not it makes sense and to give the court a recommendation mm-hmm. to approve or disapprove the various accounting requirements, filings that have to be made. Mm-hmm. Ultimately, the judge decides whether to approve things or not, but the probate examiners make the initial mm-hmm. recommendations, as do the probate investigators with respect to, does this person in fact need a conservator? Mm-hmm. So we know that in Britney Spears' case, she's had some mental health problems that may have been induced by substance abuse, but in any event, she still has a conservatorship.
Okay, and now right now her father
correct.
has been acting as the conservator.
Correct.
So what leverage does
correct.
she gain by having a fiancé become a co-conservator? Does he have the same kind of ability to control her finances as her father does?
Well, that's interesting, and the answer is yes, but they can, by court order, limit and my understanding, and I haven't reviewed the file, but from looking at the media reports on this, it appears that the father's doing the big picture kinds of financial things, and that the fiancée is doing the day-to-day financial things. So they have divided her estate responsibilities up between these two people. Now, I'm assuming that there's just one lawyer involved. You would have multiple lawyers if you had potentially a conflict of interest between the two conservators, and it doesn't appear, because of the limited responsibilities that the FINA say the word has, it wouldn't appear that there's any kind of conflicts. And again, the court's going to review the filings, and the court will only approve if the court feels that they're in order, and the court will also be approving attorney's fees and accounting fees and all those various kinds of things.
Would this kind of situation give you the the reason to believe that she's having some sort of disagreement with her father regarding her affairs, and that she wants somebody else to have a say, or is it just because it looks like the way that the article is written about this is that one of the things she wants to do is unload this house that she's been trying to sell in Beverly Hills, and up until now she hasn't been able to do that?
Well, I only know in terms of the same reports that you have read. That's a possibility, I suppose, but I wouldn't be inclined to think that.
Okay.
And the reason why is because the father has the overall responsibilities. They have parceled this out in terms of what's going on, and perhaps the fiancé has been able to demonstrate to the father that this is the right thing to do, and that he's on top of it, and that he'll make sure that it is sold for the right amount, and that she'll be moving into an appropriate place, etc. So the father might have been reluctant before, just because he was probably overworked. I can only imagine that given her success, that she has a great deal of wealth, and that he's probably full-time employed just managing her various financial assets. And he ultimately is personally responsible, because when she ultimately regains her capacity and the conservatorship is dismissed, and I have no reason to believe that at some point, whether it's within the year or following year, at some point she's going to get back her capacity and will regain control over her person and her estate. If there's something that she feels that he did incorrectly, he can be sued, which is always, when people think about being someone's conservator, I don't think the average person realizes the legal responsibilities besides the moral responsibilities that they have. And if someone has some kind of significant assets, and if mistakes are made, assuming that even if they were in good faith, they can get sued. Let's
close out with, let's talk about wills, and give an example here about someone who has maybe a large estate, but they suddenly develop a capacity problem, and the will hasn't been finished, or it's not done, or there isn't one. Does that automatically sentence the estate to probate, or is there some other way that a will can be put together?
Well, what would happen, and this happens frequently actually, because incapacity could come on suddenly because of a stroke or a heart attack or whatever. The court is petitioned to allow the conservator to do an estate plan, and in essence, the conservator signs in place of the person who's conserved, and the court will also approve the estate plan. The other thing that what becomes more dicey, however, is the health care directive. In terms of the fact that this person just decided, and mentioned to family members that they did not want prolonged, let's say, resuscitation or something like that, or to be kept on machines. So that would require ultimately probably petitioning by the conservator to remove those appliances if in fact they're present. So the moral of the story is to, while you have the capacity, since we never know day to day, could be a car accident, anything, you need to take care of this stuff.
Well, we appreciate you sharing your expertise with us, Judge Hyman. Thank you.
Thank you for the opportunity.
And you're watching the Legal Broadcast Network and the affiliate, the Family Law Channel. Thanks for watching.